No viewers yet. Okay, so let's test it and make sure it's working everywhere.
Oh, there it goes. I was like, there's no way we have no one because we have questions already. I think we're in.
Yeah, we can get started.
Cool.
Hello, everybody. Welcome to our weekly immigration talk. Curtis, what have we named our weekly talk?
Let's talk immigration.
So I think the point of this weekly talk is to answer questions from anybody and everybody about what's going on in immigration and kind of give updates on new and hot topics. And we'll start doing this every week. Do we settle at 6 p.m. EST every Wednesday?
Mm-hmm.
All right. So 6 p.m. EST, Eastern Standard Time, every Wednesday we'll be here, Curtis and Rafael, and we'll be joined by a guest. Today our guest is Alex George, one of our associates here at the office.
Yes. So,
okay, to get started, Curtis is going to give us an update on diversity visas.
Correct. So we have a lot of clients, former clients that were diversity visa 2020, 2021, and 2022 selectees. And I just want to spend a few minutes talking about each of those so that get those questions out of the way. Get those, I know what the question is going to be. So for DV 2020 and 2021, if you're waiting on the obstacle that we're waiting on to be able to shepherd our clients to visas is we need to beat the Biden administration's appeal. Rafael made oral arguments in September before the Circuit Court of Appeals for the District of Columbia. And we are waiting for that 3-judge panel to make their decision. And we don't know how long that will take. A former judge once said that their goal is to issue an opinion in 3 months, which would be in December. However, they don't meet that goal a lot. So I get asked a lot, when will this happen? We don't know. That's the answer. Next, moving on to DV 2022, we represented a lot of DV 2022 selectees and over 50 lawsuits. And for whatever reason, the State Department decided to exhaust, that's the word they use, all the allotted visas that Congress had allotted. Congress allotted 54,850. And I don't have the exact number, but it was about 1,000 more than that they used, if you count the number that USCIS used with adjustment of status. That's not the first time that they've blew an allotment, but it's the first time they've done it for the diversity visa program. So because that happened, because 2 things happened. No federal judge reserved unused visas, and 2, there were no unused visas. DV 2022 journeys are over. If you were issued a visa, that's great. Get into the United States. Go to the airport now with your visa. If you were not issued a visa, need to look to the future, look at other options because DV 2022 is over. And DV 2023 selectees, you can hire us to represent you. We charge $2,000 for that. $1,000 up front, $1,000 when you get the visa. You can find that link on our website. So that's
Great.
The updates.
Diversity visas the updates have gotten a lot simpler, I think. So straightforward, at least, for a lot of people. So not much nuance going on now until we get the opinion from the DC Circuit Court of Appeals, and then there'll be lots of questions and lots of opinions and lots of things going on. So DV 2020 and DV 2021, just hold on. We're almost there.
We're almost there. That's great. So you want to jump into questions, or you got anything else to add?
Sure. No, that's all I have here. We can jump into questions. If anybody has any questions not related to diversity visas, we can jump into those. And we can speak about that. If anybody has any questions, the floor is open for those.
Yeah. I'm curious what you all think of my hair today. If somebody wants to talk about that, that's fine too. So, okay, so the first question we have up here is from, I'll put it on there, Ida Omar. I want to know when the visa will be issued. When you have a specific question about you're a member of a lawsuit, you need to say what lawsuit, and that's very helpful. Assuming that you're DV 2020 or 2021, we have to wait until we beat the Biden administration's appeal. So,
we got a question here, Curtis. Curtis and I and Alex were speaking a little bit about this earlier, given yesterday was election day. So this question from Omar is, hi, Mr. Morrison, what do you think about the immigration bills? Is there any hope in the Senate?
right. So by chance, I had a call this morning with former Congressman Bruce Morrison, who helped write the Immigration and Nationality Act back in the 90s. And he gave me some really good insights. Basically, do not expect anything to happen between now and December in Congress. But if Democrats are able to squeak out a lead to keep the Senate and the House, there will be, and maybe if they don't, there will be probably an omnibus bill. Is that how you say that, Alex? Omnibus? Okay, in December. And the Ming Amendment, which recovers unused DV 2020 and 2021 visas, very well could end up there. Okay. But I wouldn't count on it. It's one of those things that it's a possibility. Before I'd said Congress won't help. It's possible that it does help, but it could happen. But one way it will not happen is as a standalone bill. If you put the vote before Congress on whether to reserve unused visas or whether to do any single immigration thing at all, it's not going to happen. But if it's slipped into another bill, like the omnibus bill that covers lots of things, then it could get through. So I don't know what my confidence level is. I was surprised to learn today that is still a possibility.
Right. And there's a lot of some bipartisan support on a lot of the some immigration things. So there's some Republicans that want to do some things on immigration. So there's still some hope out there. So we'll see what happens.
Yeah. So
we'll start looking through some questions here.
Well, I'll show this one anyway. When will we have our decision on the appeal for good luck? We do not know that, and I need you all to accept that we don't know that. No one knows that, okay? Anne says pleasant evening. Pleasant afternoon from California. Hello, Andrew. What is your expectation when the appeal judgment is issued? I'll give my answer and let's see if Rafael and Alex agree. I don't have an expectation about something I can't know. I only have a hope. I don't have an expectation. Do y'all agree?
Yeah.
I would agree.
Lena says hi. Bilal is DV 2021. Important to distinguish that not all DV 2021 selectees have a journey forward. You must have either been a plaintiff in the good luck case or benefit from the Ray order. James, I talk to you a lot. Good evening from West Africa. We have a lot of hellos. I need some hard questions, y'all.
So here's a question we have from Lena. So after all said and done for diversity visas 2021, can you adjust your status in the United States with I assume that's a B1 visa? Now, while there is some, you can adjust your status in the United States after entering on a B1, B2 visa in some circumstances. It's unsure whether or not the orders that were issued by Meta and Judge Chutkin will allow for adjustments of status. So if you're counting on that adjustment of status and you're in the United States, it may not be a good idea for you to count on that adjustment of status. So don't put yourself in a situation where you would find yourself inadmissible if you had to leave the United States to get an adjudication of your diversity visa. But that said, our office does handle adjustments of status. If you are looking to adjust your status outside of diversity visas, give us a call and we'll be happy to give you a consultation about adjustments of status in the United States.
So, something that came up with my call with Bruce about that very issue is there's a strong argument that they should have to do the adjustment of status, because adjustment of status for a green card is based on whether or not you're eligible for a visa. And if we beat the appeal and we win summary judgment and good luck, those plaintiffs are eligible for a visa. So they should be able to adjust status, but it may be a fight. So I wouldn't trap yourself in the US, like Rafael said.
And it would seem counterintuitive if your circumstances have since changed since the order was in place, that you wouldn't have be eligible for certain other avenues to receive your green card. So we'll wait and see. It may be that the processing begins and there's a second fight before judgment about whether they have to do this, and that may put you at a disadvantage because there may be processing of visas taking place, and we all know there's a limited number of visas. You may want to, get yourself in the line that's moving rather than wait in a line that's being fought over.
Right, and we actually filed a lawsuit, our firm did, that's before Judge Mehta, that concerns the adjustment of status question. So maybe Judge Mehta will be the judge that forces the State Department to do the right thing. That's what we're hoping. So, this is a fair question. Krill says, what will happen next with DV 2021 after the appeal court with a positive decision? With that one, Rafael?
If there's a positive decision, then the record will go with the court cases, both Good Luck and Ray and Gomez will go back before the respective judges. We'll probably have a status conference hearing about what's going to happen next, and then we'll start to have discussions of what the processing looks like. So we'll start talking again in front of the judges that issued the decision to begin what's going on.
One distinction I'll make, since he did say DV 2021, is Go plaintiffs and Ray eligible plaintiffs should be ready to go straight to resuming adjudications and interviews. Good Luck have one more stop before we get there. We have to win summary judgment.
Well,
which
I anticipate that if I don't think we would have to go to the summary judgment phase. I think the judge would be I think Judge Mehta will now know that the circuit court agrees with him. He knows that he is going to rule in a certain way. And I think and it would be easier if the processing was all going together. So he may parse it out to say, Go plaintiffs go first and Good Luck plaintiffs go second. But he may just come back and we may ask him to reconsider his initial decision on stopping the processing of Good Luck plaintiffs and just say, let's get this ball rolling. And he may be inclined to do that. So there is one more stop. Without a doubt, that we have to go back before Judge Mehta to tell him to start that processing up.
This is a peculiar question. I don't know if I know the answer. Only plaintiffs from previous fiscal year can check visa status on SEAC. Oh, I know what he's asking. He's probably a DV 2023 selectee, and he wants to know why DV 2023 selectees cannot check SEAC until January 1st. I don't know the answer. I just thought I would interpret the question. Does anybody know why the State Department doesn't let them?
Well, I think it's just bad programming. I think they're still using the first Apple computer to run their SEAC website or something like that.
An Abacus or something? Yeah,
it makes no sense. And from the look of their hiring practices, they're constantly running out of money. So they probably don't have money to do that.
Yeah. And my really cynical 2 cents on this is the more data they retain, the more we can FOIA for and the more we can find patterns of wrongdoing. So, they probably have, and I'm sure they do, have a default data retention policy. But I am guessing those timelines are engineered to limit their liability.
Yeah, probably.
Again, I know it's cynical, but based on what we've seen, I don't think it's a stretch.
Our profession, it's healthy to be cynical. I only wanted to ask now about the judge still holding me his government ruling. What is your plan B? Well, our plan B for DV 2020 has always been legislative. Like we did what was called Project Voyager, where we funded a lobbying effort. And like I said earlier, I talked to that lobbyist this morning, and even though we can't afford to pay him anymore, he's still got this on his agenda to see if he can get it in the omnibus bill, where he reserves unused visas for DV 2020 and 2021. Recaptures, that's the word, recaptures. Judges reserve, Congress recaptures. So that's a plan B, but I encourage you to look for your own plan Bs. I would say enter DV 2024, but that deadline was yesterday. So look for your other, be resourceful. There's employment visas, there's family-based, there's investment visas.
Yeah, and I know that we kind of wanted to, in these streams going forward, kind of expand the immigration discussion a little bit beyond DV. Like, DV is obviously very important to us, but, if you want to talk about Plan B, let's, toss us some questions. Let's see what kind of Plan Bs you want to know more about.
Right. Alex happens to be sort of a very knowledgeable person, a very knowledgeable attorney about the O1 visa. Do you all know what an O1 visa is?
It's a very weird little niche I carved out for myself in my first year of practice. Sometimes people call that the Einstein visa, although that's really the EB1, like the green card version of it. But that's for, the cool thing about the O1 is that it covers so many different fields. So if you're at the top of whatever it is you do, I've had rock stars, professional soccer players, CEOs. I had some disinformation experts. Those were fun. And I actually got to co-counsel on an O1 for a photographer who got what I thought was a totally ridiculous denial. And that worked. That got the decision overturned. And now she's here doing experimental photography. It's a wild thing. But if you are, really kind of at the top of your game, it is worth exploring. This is also a good one for, since we're all online, if you're an influencer, an O1 is a viable option, and there are ways to kind of build up toward being qualified for it. I worked on a lot of those. You'll have to stop me. I could talk about these all day.
That's okay. So maybe there is a reason to pay $8 for that blue check mark. Right? That's a Twitter.
Actually, we should talk about that too. We were kind of, before we started the stream, we were talking about what the hot immigration news was, and maybe we can do a little bit more on the midterms in a bit. But since you brought up Twitter, but I've been following, there have been, as you know, huge layoffs at Twitter, huge layoffs at Meta, and Meta, Facebook, is considered an H-1B dependent employer. They have over 15% of their employees are H-1Bs. And they've done huge layoffs. And so now they are, I think, kind of having to backpedal, because I don't know how much they were going to do for their H-1B employees initially. And there was a lot of pushback online. And then suddenly Meta is making their legal team available to them. So I don't know. I think it's a good way to kind of keep the conversation going about, yeah, their employment-based visas are an option for a lot of people if you got the right education, right skill set. But it's a double-edged sword, because, you'll need a plan C. You can't be on the H-1B forever. And the H-1B, if you lose your job, you can lose your visa. So this is why it's worth your while to talk to an immigration attorney who does these regularly.
I lost my place in the questions. Oh.
Yeah. So another hot topic that we're knowing, and I think this is would affect a lot of Venezuelan diversity visa winners for DV 2020 and DV 2021 who didn't get their visas for whatever reason, because many of them have some contacts in the United States. So, what part of that, the Venezuela parole process is, it's a 2-year parole that gives you authorization to travel and temporarily remain in the United States for up to 2 years, right? You have to have a supporter in the United States, undergo security vetting, meet some other criteria, and then warrant favorable exercise of discretion. What that essentially means is that there's nothing bad in your record that would make immigration officials here in the United States question whether you deserve to be paroled in the United States. So if you're committing crimes or punishing dissidents in Venezuela, they probably don't warrant that exercise of discretion. And so there's been a process set out in place for those individuals. If you think you are eligible for Venezuelan parole, contact our office. We'd be happy to talk to you about the process and how we can help you with that whole process to get you to the United States.
Okay, I have a curiosity question about that because I'm not super familiar. In other exercises of discretion, sometimes it's like a balancing test. So even if you got something on your record, if the good outweighs the bad, you can still get a favorable exercise. Does it work like that, or is it stricter?
Well, I mean, the parole process is new for Venezuelans. I think they're going to be rather strict in this one. But yes, the warrant a favorable exercise of discretion is a balancing factor, no doubt about it. So if there's more good things going on for you, there's than bad things, I think you'll still get warrant that exercise of discretion from the Department of Homeland Security.
Cool. Okay. I see we've got some enthusiasm about the O1 in the chat. That's nice to see. I should probably tell you that the O1 is the highest standard in immigration law, and it's real tough to get. If you just Google like O1 criteria and you plug in whatever it is you do, like O1 chef, there are people who have done this before you who will kind of, and like immigration lawyers out the wazoo, who will kind of explain to you the types of evidence that you might need to build that up, or what you could use if you've already got it. They're tough to get, but they're doable. And the reason they're tough to get is, extraordinary ability is a really high standard, but also there's like a green card equivalent, and that's a pretty nice perk. And for folks who are from backlog countries, the backlog for the EB1 is, at least the last time I looked, is not nearly as bad. Actually, while we look for our next question, I'm going to pull up the visa bulletin because I'm kind of curious about what it looks like right now.
So make sure I understand this. O1 is a non-immigrant visa.
Correct.
And the EB is an employment visa that gets a green card.
Yep.
So the EB is preferred.
Yeah. And I usually tell people if you feel like you might want the EB1 in the end, to try to get the O first, because it's kind of proof of concept. Like, you can show that you've already qualified based on extraordinary ability once, so you could probably do it again.
Oh, okay.
So here's a question from a listener. What are my options for adjustment of status if I'm an F1 visa holder? There's several options. We would need to know the basis of your adjustment of status, what else you were qualifying for that would allow you to adjust status to a green card holder. So you would have to, I would encourage, if there are some options that you're already exploring, contact our office through email, Telegram, or phone, and we'll be happy to discuss that with you.
Okay. I see a question on Twitter from Allah. He said, is there a new case in the good luck case? I think he means, is there a new development? There is not a new development since September the 15th or 16th, when Rafael made oral arguments in DC. That's the last thing we know. So.
Right. And I can say that I think oral arguments went very well. I didn't find the bench hostile to us. They had questions hostile towards our positions. In fact, I felt that they were more hostile to the position that the government has taken on ineligibility. So I'm extremely confident that will prevail.
Okay, so someone's asked a complicated question that you're going to need to have your friend message us directly. There's just a lot to that, and then you weren't able to fit the whole question there. Morrison Urena is unique amongst immigration law firms because we do not charge for consults. We charge you only if we represent you with an immigration process or to participate in a lawsuit.
So Sahar has a question here to Alex. If the person applying for an O1 visa is already in the United States, can you help them with an adjustment of status, or are they eligible to adjust status?
They can be. I've done this a couple of times. This tends to work better in like an academic context. So like I've had folks go from J1 researcher to EB1 green card. But to do that, like, you know, you're really shooting for the moon. Like the way the language is written in the law, it says, this is clunky, but this is what it says. Like you're among the small percentage at the very top of your field. So, you know, it's your field however we define it. Like you don't need to be Jimi Hendrix, but you do need to be like a Gary Clark Jr. Like you need to be recognized in, like, I would say Santana is probably like one of your greatest like Latin fusion guitarists of all time. Like that's how we would define his field. Because if you do it too broadly, you're putting yourself up against everybody. So I would say if you're interested in that, you know, first of all, get on the USCIS website, go look at the criteria. There's 10 of them. You want a strong 3. And then talk to an attorney about, you know, why you feel like you've got a strong 3 and what evidence you can provide. But the best way to get ahead on this is understand that like a USCIS officer is going to have a very kind of American-centric view of your professional achievements. And I think sometimes folks don't like to brag on their accomplishments or don't feel comfortable selling themselves, or, you know, maybe you come from a place where that's not normal or encouraged. This is not the time to be humble about your accomplishments. You know, you really want to lay it all out there because you're shooting for the highest, toughest green card there is. But yeah, if you qualify, it's totally possible. You just have to be kind of careful about the timing with travel and stuff if you have a job that demands that. Because if you're not on a dual intent visa, you've got this pending, something happens, you've got to leave, you're going to be stuck until you can get an appointment to come back in. So it's not a thing to DIY. I would definitely talk to somebody who does these a lot.
A couple more questions. Raheem asked, he's not a plaintiff of DV 2021. Should he keep hope or not? The answer to that question depends upon which embassy you were waiting on, because there's another judge besides Judge Mehta, Judge Chutkan, who gave relief to 25 or 26 different embassies where people were waiting for interviews. It's called the Ray order. So you'll need, Islamabad was, I see was your answer now. That was not one of the embassies. They got relief from the Ray order. So your DV 2021 journey is over. Sorry to deliver that bad news publicly, but focus on the future, because DV 2021 for you is no longer a path forward.
Great. I have another question here from Lena. Okay. Now I can't see the question. Does somebody want to read it to me? Because it's blued on my.
I also want to find out, if I have a B1 visa in the U.S., then I gain admission to school, how can I adjust my status without going back to my home country?
It is permissible under certain circumstances to change from B1 or B2 non-immigrant visitor status to an F1 or student visa status. However, you have to maintain your visitor status or otherwise be eligible for what's called a change of status. So it's not an adjustment of status, it's a change of status to satisfy immigration that you did not obtain the B1 or the B2 to circumvent the application process. So it is possible. I encourage you to reach out to us directly, and if you think you're eligible for that, and to reach out to us directly so we can discuss the case in more detail about what you would need to do that.
I want to say something about student visas since we brought that up. A lot of the people that have been with us for the DV journeys and for the family preference category journeys are probably thinking, oh, student visa, new process. I don't want to wait through another process. Completely different. Student visas do not take years. They're relatively quick. That is a priority of this administration. So if you're thinking about studying in the U.S., do not be intimidated about the time period, because they will make those things happen a lot faster. But the first step is to get admitted to a U.S. school that you can afford, because you won't be able to work while you're here, and you're going to need to pay that tuition.
And you're also going to want to think about your next steps, because depending on what you're getting your degree in, you'll only get so many years of work authorization. If it's a non-STEM degree, you only get one.
Right.
And you're not guaranteed it, is the thing, which is, it sounds counterintuitive because, there are other countries where they have that built in, but that's not the case here. So you'll want to make sure that if that's an investment you want to make, that you've got an exit strategy, or the opposite, a strategy to stay if that's what you want.
Amar, I think you're asking about an individual specific case, and I don't think we can do that here.
If we represent you, you've got our email. Feel free to reach out to us directly.
Yeah. Okay, here's a good one. Simply says, I'm a U.S. citizen. My mom is here on a B1, B2. Can I apply for her AOS? Can you all help? Rafael, let me think here.
Kind of depends on how long she's been here, right?
Right. I need to know, do you have a pending?
No, if you're a U.S. citizen and your mom is here on a B1, B2, you can apply for adjustment of status. You would have to apply for I-130 first, and then she would need to adjust status. And she's an immediate relative, so she would be able to adjust
concurrent. That. We could file them both at the same time, right?
Right.
The reason we really need a consult for that, because we need to know when the B1, B2 expires. Yeah. Okay. So here's asking about family visas and the cost. And I think I know why he's asking. He's connected with the DV community a lot. And when you get in the US with your green card, you're like, okay, can I bring my family? And when you are a green card holder in the US, you can only petition your spouse and your children. That's it. But we do offer that service. We charge $3,000 for a basic one petition of one human. If you're petitioning a spouse with 10 kids, we might need to charge you more, okay? Because it's going to be a lot more work. And also the USCIS petition fee is $535, not too bad. But like I said, green cards cannot petition parents, just spouses and children. Now, once green card holders become US citizens, then they can petition not only their parents, but their siblings, okay? The sibling wait, the parents is immediate, like a year or two. The sibling wait is ridiculous. It's like 14, 15 years, something like that. And I had an interest in the conversation I had this morning with Mr. Curtis Morrison. He pointed out something to me that I hadn't thought much about. The F4 category for the siblings, mathematically, they didn't really think about this when they made that designation. It's going to spiral out of control to where eventually it will not work, because every time there's an immigrant, there's more siblings and there's more petitions, and the backlog continues to grow, and eventually it's going to exceed the visa bulletin backlog will exceed the lifespan of your siblings. It's very depressing. Rafael's like, what?
No, I think that I was just saying that I think if you have a younger sibling and you're older,
it's going to exceed your lifespan too.
Yeah.
Right. Is there an opportunity for humanitarian reinstatement? It's going to be complicated stuff, but yes, there is complications with that. It's similar to Indian EB visas, where the wait times are longer than anybody would stay alive, right? So
right. And Congress needs to fix some things, but Congress is not known for fixing things. So.
Right. Or eager to provide relief to immigrants is not something that Congress seems keen on right now, but we'll see.
Right.
Yeah.
But Morrison Urena does do family-based petitions. We enjoy representing you at all parts of that process, from preparation and representation with the I-130 form or the I-129F if it's a fiance, all the way through consular processing, including any requests for evidence along the way or what have you. We enjoy that.
I have a question here from Anne. What if I have a U.S. green card? Can I apply for my 25-year-old child? Your 25-year-old child, you can apply for them if they're unmarried. If they become married at any time during the pending I-130, before you have become a United States citizen, they would lose eligibility and no longer be able to immigrate to the United States on that visa. So the answer to your question, yes, if they're an unmarried child, and they would have to remain unmarried until, 1, you became a United States citizen, or 2, they immigrated to the United States.
And I apologize earlier for not saying unmarried. When I said green card holders can petition their spouses and children, I should have said spouses and unmarried children.
Right.
And for immigration purposes, stepchildren and adopted children are treated just as children.
Exactly.
Right?
Mm-hmm.
We get that question a lot.
It's one good thing about immigration, that they treat the step kids like the regular kids. So there's no problem with the stepdad petitioning the son or the daughter or the stepmom, either way.
Abdul has a question here. He had a tourist visa, and he broke the visa and returned from the United States airport in 2002, and he wanted what I believe is diversity visa 2023. Does this breaking the tourist visa, I'm assuming this overstaying the tourist visa, affect obtaining an immigrant visa? You would need to know the length of your overstay to make a determination of your inadmissibility. If it's longer than 6 months, then yes, you will have an inadmissibility situation, and you would have to remain. But if it's 2002, it looks like you've already satisfied the terms of staying outside of the United States for 3 years or 10 years. So I think you're going to be fine.
Yeah, I would want to know more about what he means by broke the visa, though. We're assuming it means that he overstayed. I guess that's the only thing it could mean. Broke the visa. I don't know.
Anne has a follow-up question on how long does it take to apply for a child over the age of 21 when you are a green card. I think the process is about 7 years now. I think wait times are 7 years. So assuming that they would continue to adjudicate at the pace they have, it would take about 7 years for that visa to become current.
And in that time, your unmarried child can still apply for the DV lottery. I get asked a lot, hey, can I do 2 different routes? Can I apply for the DV lottery even though I'm a selectee from a different year, or because there's a petition out for me? And say, of course you can. You can pursue more than one route and see which one gets you here first. It's a good idea.
I think there's also a lot of anxiety around F1s who are in the United States and win the DV lottery. They're afraid to adjust status because they're afraid it's going to look like an intent problem. This was their grand master plan all along.
Right.
I just personally the odds of you winning the lottery are so small. I don't think you can have preconceived intent. Like, how would you know that you're going to win?
Right.
People enter multiple times and never do.
Right. And in my experiences in the past, seeing F1s adjust after diversity visa, there hasn't been an issue with that at all.
No.
So I wouldn't be too concerned about that.
We represented one this year that didn't even require an interview. Was it just one like that, I think? Yeah.
Just one.
Yeah.
But still, yeah, they just skipped it because it was so close to the end of the year. It was wild.
Yeah.
Remarkable what immigration can do when under pressure.
Yeah, when they feel like it.
Yeah.
Right. Right. Okay, I don't see any more questions. I can't believe y'all don't have any more questions. Come on.
I'm sure the questions are going to, as we run through, do this more and more often, people are going to start showing up more often with questions to ask.
Right, right. I'm wondering if there's anything that I can just throw in. Asylum, Rafael. We've got a lot of people on the southern border thinking about going to a port of entry and requesting asylum in the United States. Do we offer that service?
Well, we don't offer the service of transporting you to the port of entry for you to apply for asylum. That's not something we offer services for. But if you do find yourself in a situation where you want to apply for asylum in the United States, wherever you are in the world, we'd be happy to discuss that case with you and tell you what the rights are and what the processes are for applying for asylum in the United States.
Right. There's only 2 places you can apply for asylum, though. Where are those 2 places?
They're at a port of entry or inside of the United States.
Right, right. I get a lot of questions from people in conflict areas, Russia, Iran, saying, oh, I want to apply for asylum. And I understand and sympathize with all the reasons why you need to apply for asylum, but you can't do it from there.
Right. That would be called the Refugee Resettlement Program is what you would apply for. Immigration attorneys have very, very little, almost nothing to do with the process at all. It's handled by the United Nations in coordinations with the Department of State, and it's really out of your hands. And it's a long process that has been broken for quite a number of years in the United States. So, yeah, that would be the process. Patrick has a question here. He has how long the wife petition process is. So both for green card holders and United States citizens, for spouses, those visas are current. Right now, the process is taking as long as it takes for the department and USCIS to adjudicate those petitions. I have spoken with so many green card spouses, green card holders petitioning for their spouses and their spouses about the delays at certain service centers. Our office has been extremely successful in forcing the hand of USCIS to adjudicate those petitions promptly. And once we've had those visas adjudicated, depending on the embassy, is the next step of it. And that can vary wildly depending on your post of adjudication. So the short answer to that question is it depends on a lot of factors about how long that petition will take. But if you think it's taken too long for your wife or your spouse to come to the United States, give us a call, and we have avenues in which we can undertake to try to end the delays that have been occurring in those petitions.
Right. There's a huge disparity in how long it takes based upon the embassy and also the visa category too. Like U.S. citizen spouses usually quicker than green card spouses.
Right, and even service centers at the USCIS stage are differing wildly about how long it's taking green card holders to petition their spouses, which is crazy. So I've spoken to many people at the Potomac Service Center and who are at the California Service Center who complain about long delays in their petitions for their spouses.
Right. Yeah, Patrick said he's a U.S. citizen, so that's one advantage you have. But there's still embassies like Abu Dhabi Ankara to a lesser degree in Islamabad that have huge backlogs for the immediate relative categories. So the embassy matters. And if you have the means and mobility, your beneficiary has means and mobility, like they can travel, get them in a country that does not have a backlog,
Right. Or if you have some discretion in the choice, if you're a homeless applicant, if you have some discretion in where you can get your visa adjudicated, take some time to speak to an immigration attorney about what's going to be the best route to take on your decision.
You said homeless applicant. I think you should explain what a homeless applicant is.
Right. A homeless applicant is somebody who doesn't have a embassy or consulate in their country that is processing visas. So essentially, they termed it homeless, but that's what it means.
But
Iranians, do you have any?
Yeah, but it's got to be on the list, right? Like we've seen countries where everything just like shuts down for 6 to 8 months, but unless the Department of State puts it on that list, it's not considered homeless yet.
Right.
That's true, but that doesn't necessarily mean that you can't get an interview in another embassy.
It's just more discretionary then.
Right. It's up to there's a lot of discretion with the embassy you want to go to. And what we found is if it's a small embassy and the consular officer doesn't have anything to do and he read your email and you have or an email from us, either one, and it has a very compelling reason to do your interview there, and you can stay 30 days. That's in the Foreign Affairs Manual. You have to be able to stay in the other country for 30 days. Then sometimes that can happen. Usually the air tickets are very expensive to these kind of locations. So it takes means. So, but
sometimes, if you're coming from a far way away, your trip to the United States is less expensive too. So it's just a stop along the way.
Right. Sure. So, I'm getting repeat questions here.
So Patrick, reach out to us, and we'll be happy to discuss your case, and we'll see if there's ways we can. We're happy to tell you what we think the processing time is going to be, and if there's any way we can make that shorter for you, we're happy to discuss it for you.
Mm-hmm. A lot of times, if you're at the point where you've done everything you're supposed to do, and you're still stuck at USCIS, a year or two later, you can explore the possibility of a lawsuit. I think a lot of people are kind of afraid to do that because they're worried about like backlash. But I think we've seen, and y'all can correct me if I'm wrong, at least I've seen it's got the opposite effect.
Yeah.
It speeds things up.
Yeah, retaliation doesn't really happen.
And I think it actually, when immigration officers understand that there's eyes on a case, they're usually more inclined to grant a case because they know that if it's denied, there's going to be scrutiny of that petition. So that's just my take on things when I'm dealing with these cases.
Mm-hmm.
Absolutely. Okay, so I've got some latecomer DV 2021s that are asking the repeat questions. If you're a plaintiff of DV 2021, I think that means you're a good luck plaintiff is what you're saying. You have to wait till we beat the appeal and then wait for summary judgment. We don't know when that's going to be, but we hope it's soon. So we can wrap this one up early since we don't have any questions, unless you all want to talk about the weather or something. It's been raining in California.
No, I think this is going to be great. I think this is going to be a forum that many people use to get their immigration questions answered. If you are in the United States or outside of the United States and your friends have immigration questions, tell them to tune in on Wednesdays, 6 p.m. Get their questions answered, and we'll be happy to help with them. So I hope next time there's a lot more people with a lot more robust questions, and I'm sure there will be.
If not, I'm going to sing.
I have never heard you sing. Do you sing, Curtis?
No, that's why I'm hoping that there's people with questions.
Maybe we can talk about the midterms.
Do you sing, Alex?
Not well.
No. Okay.
You play an instrument.
I do.
What instrument do you play?
So I grew up playing jazz. Like I played saxophone for most of my life, but I started taking piano lessons in law school just for like my sanity, just to do something else.
That's the coolest thing about you played a saxophone.
I did.
That's great.
It's like Bill Clinton.
Yeah, no, you could be
Except a
president.
little cooler than Bill Clinton.
Right.
Yeah, he's like 90 years old. How cool can he be?
Right.
But when he played that saxophone, he was the coolest man on. Was it Letterman or Leno that did it? It was
Yeah, it was like the first time a president was like approachable. That's wild that was
You had
groundbreaking.
some rhythm.
I did.
Yeah.
Right.
All right, guys. See you guys all next week.
Okay. See ya. Bye.
Thanks,
Adios.
Will.